Well, thank you, George. Everybody comfy? Chris brought a statute book. That's not fair.
George had a formula.
That's true. That's true.
Sort of counter that.
What's really great about this panel, by the way, is that we've actually all worked together at the FCC. I worked with Paul years ago when we were junior staffers in the Cable Bureau. We had Kathy Brown from Verizon, who was the former chief of staff at the FCC when I was there. We had Chris Wright, who's the former general counsel of the FCC when I was there. We have Dr. Nuechterlein, who was there, the deputy general counsel there, and me, a little old staffer. So we kind of have, you can see the pecking order from the 8th floor coming right on down to me. And look how it's all turned out. We're all here. So I want to thank everybody for coming. And I think George set the stage for the discussion. And there's a lot to go over. I think where I'd like to start, so I get the right questions, is I'd like to start with Kathy, who's works at one of our major broadband service providers, and just get her initial thoughts of what is going on, how is this going to affect your business, what are your concerns, what are your praises. We'll start with that as an intro question.
First, I want to thank George for noting that the guys up here are smart. Good morning, everyone. Here's where I start with this, and I guess I start with where we started, which was an understanding probably 10 years ago or more that the entire space, if you will, was changing, and that what were cable companies and telco companies and wireless companies and broadcast companies and something we didn't even know at the time, applications companies, which we just thought was what, software, I guess we called it, that something was happening. It always amazes me that the word convergence, remember that's all we talked about for about 7 years? Nobody even says that word anymore, and that's because it's happened. Because what we thought was going to happen has indeed happened, and that is all of these modalities became something else altogether because of the internet. And we're in the internet age. And I think there was an understanding at the time, and it was hard fought. I'm not suggesting that we all of a sudden divined the future, but there was an understanding around the open access fight with cable that it would be short-sighted and perhaps going backwards with respect to policy to take wholesale a statute and a set of requirements that were developed for an entirely different market, and a market that frankly was a government-regulated rate of return market. And somehow we sort of forget that Title II was about a rate of return regulated market. And so I get nervous even when we start talking about this statute as even relevant to the age in which we now live. So I start there. So I understand a little bit, having been a regulator myself for 20 years and having gone through experiences where the court gives you a little, hit on the knuckles. I understand the reaction and the institutional urge to make sure that what you believe Congress has told you to do, you're able to do. So I understand the urge, the need of the government to say, wait a minute, what we cared about was whether there was blocking. We care about the end-to-end principle on the internet. And in that regard, we want to make sure that this is an open network where innovation can happen. The problem I have is we don't have a statute yet that actually sets the United States policy on how and when and who ought to be doing what and how and what. And so what I now am concerned about at Verizon is that a look back will indeed confuse, and I think George's paper does an amazingly good job at talking about how that confusion happens, that it will confuse the future, and it will confuse future decisions, and it will confuse what I think has been the engine of growth, not only in this country, but around the world. I'll say more later, but I think that's where I come at it.
Okay, great. Paul, let's turn to you. And what has Wall Street's reaction been to this? I mean, you're dealing with analysts, you're talking to folks. What have you been hearing? And please share that with us. Also, turn on your mic. Just put the on switch right at the top there. There you go. Great, thanks.
I thought people just want to know where LeBron James is going to play.
Really?
Make that situation certain, and then other teams know what to do. I think Wall Street is, they're looking at this and they're a little confused by it, and I think that they want to steer clear to a great extent until they see, how the dust settles on something like this. I mean, there's a lot of focus on certainty and uncertainty, and investors wanting certainty. I mean, to some degree, uncertainty is what creates your edge, creates your opportunity. If you can sort of game out how you think things are going to play out, right? Certainty will be reflected in your prices. It's too late to get in on secondary markets. But if you're talking about a, big institutional investment or going to the bond market to raise capital for more fixed investment, it's definitely a concern. I mean, I think the certainty-uncertainty formulation is almost really the derivative question. I mean, it's really risk-reward, right? Investors deal with uncertainty all the time. And when you impose a risk that your upside is going to be capped on a major structural investment, then your cost of capital goes up. I mean, there's a substantial risk now that something unforeseen, you can't predict 10 years down the road, could come along and cap what could otherwise be the enormous, innovative potential of your core network. Now, having said that, not all investors are monolithic. I mean, if you're an edge provider, right, if you've got this great new application or you've got this great new service, in the cloud, there's an opportunity there. You want to invest in that, and if you can check off the risk factor on getting to the customer, having unimpeded access to customers, that's a plus for that type of investment. If you're a venture cap or private equity, any investor, and someone comes to you wanting money to build out some sort of an application, it's a great idea. There's a risk factor. They say, what happens if the cable or the telco product extends into this application or affiliates with someone who wants to do the same thing? Competitive application, what's your protection? And I think those in support of sort of more aggressive regulation here would want to be able to check off the risk factor. Well, that's illegal. They can't do that. There's no issue here. So the question in the long run is how does that have effects on network investment that could actually slow innovation in terms of what happens on the edge as well. As far as the theme here in terms of credibility of the FCC, I mean, I understand what Austin Schlick is saying about how hard it would be to unforbear. I know that the case they're making for that, but it's a legal case. I just don't think the investors will take that risk. There's just no way you can guarantee the policy prerogatives of future chairman for investments that take a long time to play out. So I don't think they'll buy that, and I think therefore that's a risk factor that I don't think it's easy to smooth over.
All right. Well, let's move to to Chris and John for a minute. Let's start with a real simple case. Why do you guys think that the commission lost in Comcast?
Well, I'm happy to take a shot at that.
Okay.
I don't think the commission is fabricating a legal crisis, and I don't think that that it's simply a badly written order. I think there's been a trend, a generational trend over the last 60 years for the courts simply used to like letting agencies take broadly worded statutes and run with them. The NBC case, 6 years after the Communications Act was enacted in '34, it didn't cover networks, didn't cover television networks. Not a word in the statute then about networks. The FCC decided, geez, we can't do anything if we don't regulate networks. They've sprung up and they're running everything. They did so. Supreme Court, in the famous NBC case, gave them the green light. I don't think that would happen today. You get to the late 60s and early 70s with cable cases. Not a word in the Communications Act about cable companies. The FCC started regulating them in a major way. That's okay. You get to the late 80s, there's not a word in the statute about the Universal Service Fund. The FCC creates one. A big fund starts taxing people. The DC Circuit approves that. But there's really just been a judicial trend away from that. And Judge Tatel, I think he did a great job, but it's also a somewhat creative job of kind of lining up all the cases. And I don't think all the cases really can be lined up in the way he did. But he comes down to a bottom line where he repeats where the DC Circuit's been for a while and where I think the Supreme Court would be. Sort of, they want to know ancillary to what. The one thing that's absolutely clear is that you can't cite Title I anymore and Section 4I and then do what you want. And that's really what did happen, say, in the Universal Service Fund. And, you know, personally, I think this is probably a good thing in a democracy that, you know, an unelected agency can't just, I mean, Title I is incredibly broad and Section 4I is incredibly broad. So if you can do almost anything. You can regulate networks, you can regulate cable, you can create even for a service fund, if that's what you're doing. And I think we've had a shift, and that you definitely have to have a specific provision in the act, and you've got to explain pretty well how you are implementing this. And I actually asked someone almost at the commission almost immediately after the decision, sort of, well, you know, could you actually have won this case under some of these other provisions that they didn't discuss? And the answer was perhaps. And that's exactly right. Perhaps they could have, perhaps they couldn't have. And with sort of everything in the broadband plan with this multiple proceedings where the FCC doesn't even know what it's going to decide on some of these things. Could they be upheld in Title I? Perhaps. I would bet a lot of money, and you know, George would think this was a good thing, that it would win some and lose some, probably lose a lot, if it proceeded under that approach. But I do think this is kind of part of a long-term trend where courts are tougher on agencies, and again, I think it's a good thing, not going to let them take general provisions and just create things out of thin air anymore.
So in other words, they have to hook it to something.
They have to do something, and it's the third way approach. It doesn't solve all the FCC's problems, but I think when you do take a transmission path, separate the transmission path out, and call it a telecommunications facility, the FCC will, as George's chart indicated at the end, the one that isn't in his paper, the FCC, I don't think the FCC will necessarily win everything under that either. It'll be case by case, but they'll probably win more under that approach. Let me just add that I'm not sure it maps out sort of the bottom line in George's draft was heavy-handed regulation, I think, on that end, and light touch regulation on the other end. I don't think it really maps out quite that way. I think it'll actually be more random. if you can find a real close fit between what you're doing and the particular statute, some provision somewhere in Title II, it'll be more likely to be upheld, probably whether or not it's light or heavy-handed regulation, which is obviously always a matter for discussion and disagreement. And some things that we think of as light touch regulation, you probably just can't find a provision in Title II that it really hooks onto nicely. And let me just make one more comment before I give John a chance. There's kind of a counter trend in the law over the years too, where, when you had these kind of really broad provisions, the way Section 309 used to be, that sort of the FCC shall regulate in the public interest, which has now been amended so that, Section 309 takes up about 13 pages a year with all kinds of details. When you had that sort of broad thing and a direction for the commission to do something, the commission almost had to get more leeway. But when you get this multi-stage detailed provision, and the FCC wants to do something that's ancillary to it, which is that Congress has gone into great detail, but the FCC is doing something else that's sort of not in this list, there is a sort of a reluctance on the courts to say, well, wait a second, Congress made pretty clear what it wanted, and it didn't say it wanted that. And so sometimes you get the FCC and agency will get hit on the other side too. But that's part of the reason why ancillary jurisdiction may not get the FCC everything it would like to do, even under Title II. There'll be lots of fights in the future, and it will be a very detailed argument, I think, on sort of every case.
You don't think the courts would be sort of going, well, gee, we've just done all this Title I stuff here all the way up to the Supreme Court. Now you're reversing yourself. They're not going to look sort of skeptically on that.
Well, I'm sorry. Do I think sort of Austin is correct that his best legal approach, or the legal approach that's most likely to be upheld, is a switch to the Title?
It would seem to be that, you go, well, agencies can change their mind, but you have all this precedent. The courts are going to go, weren't you just here a couple of years ago? What's changed?
I don't think there's any absolute certainty here, and I don't think there's ever going to be absolute certainty for investors. That's impossible. But that's for a couple of reasons. One, as we all know, and we enjoyed so much in reading Justice Scalia's decision in the Iowa Utilities Board case, the Telecom Act is, quote, a model of ambiguity, even self-contradiction, unquote. And nobody's going to change that. And if Congress rewrites it, there'll probably just be more uncertainty and ambiguity and self-contradiction in the short run. And the second thing is, and I recommend everybody read the Fox case from the Supreme Court, which was the fleeting expletives case. But Justice Scalia really spelled out something that I think is another change in the law over the years. One that I think seemed clear to people who spent a lot of time reading Chevron cases, but I think surprised a lot of people. Agencies can change their mind, and they don't have to have changed circumstances. They don't have to have a better argument. They just have to have the same sort of permissible argument that would have gotten upheld in the first place. So I worked on the Stevens report along with Kathy and others, and we adopted the approach that the FCC is now proposing to depart from. And it's not certain that they'll succeed. You're right, and I actually think that Justice Stevens, the author of Chevron, oddly enough, might have been the justice who would have been most likely to do what you're suggesting and say something like, well, wait a second, you can't come up here a couple of years ago on Brand X and tell us that this isn't a Title II matter and now come up and tell us it is. But I think it's quite clear. I think Austin is right to think that he's got a pretty strong argument there, and that most of the justices would would view it through the Chevron framework and say, yep, you can construe the statute one way, as you did in the fleeting expletives case, and say that fleeting expletives are okay. It's only if they're repeated expletives that you're going to get fined. And then say, well, you know, we thought it over. And we just want to change our rule. Now we want to prohibit fleeting expletives too. And Justice Scalia's opinion, you know, for which I give him credit, at the very beginning of the Obama administration, just is the clearest explanation that there is that an agency can change its approach, doesn't have to have changed circumstances, doesn't have to have a better argument, just has to have a plausible argument. Actually, if you give me one more minute to talk about old cases, I'm going to remind you of the facts of Chevron. Chevron involved the meaning of the term stationary source in the Clean Air Act. And the Carter administration had construed stationary source to be kind of every pipe that, you know, emitted something was a stationary source. In what was a creative regulatory change, the Reagan administration decided to adopt something called the bubble concept. And after that, under the bubble concept, each emitter was not a source. There was a bubble over, say, a factory or whatever, and that was considered the stationary source. And so this gave factories much greater leeway to reduce, you know, to maybe cut off some pipes, but not others, and change things around. But it was also a clear, it was acknowledged as a clear change in direction, and a clear change in direction that was motivated by the Reagan administration's more deregulatory approach than the Clinton's administration. And it was upheld for that reason. They didn't have to have a better explanation for why, you know, for why the bubble concept was better. It was okay in a democracy that when the president wins and his party comes into power, you can actually change the meaning of an ambiguous statute if you have at least a reasonably sound policy reason to do that.
John? So I'm going to address roughly the same two issues that Chris just addressed. And one is, why did the FCC lose? And the other is, what's going to happen next? One reason why the FCC lost is it did not do what the FCC often does when it confronts a poorly reasoned order, which is to take a voluntary remand back to the agency from the court. Let me, for the non-lawyers in the room, here's what that means. When the Janikowski administration took over, they had the option of looking at the Martin administration's Comcast order and saying, gosh, you know, this is really overbroad in its reasoning. We have better arguments that are more closely tied to the words of the statute, and we would like to rely on those instead because we think that the court would be more likely to uphold them. They could have told the DC Circuit, give us the case back so we can do this over again. They chose not to do that. And as a result, what you saw is instead of the highly plausible reading of the Janikowski administration being contained in an order that was subject to review on merits by the DC Circuit, you saw those same arguments appearing in the General Counsel's brief. What the DC Circuit said in response to that was, under this doctrine called Chenery, we can't consider those better arguments that you came up with, Janikowski administration, because it wasn't in the order under review. Those are just post hoc rationalizations of appellate counsel. So we're going to vacate the order because you didn't include those rationales in there. Again, they had the opportunity to take a voluntary remand and to include those rationales in the order under review. They chose not to do that, and the result is the situation that we now have today, where they are opting instead not to rely on those rationales that they could have adopted in a voluntary remand, but instead give every indication of wanting to enact a sea change in American internet policy in response to this court loss, which again was arguably avoidable. At a minimum, they could have bought themselves a couple of years by taking that voluntary remand. This happens all the time with the FCC. When the General Counsel's office gets an appellate brief from the other side that it sees presents grave concerns about the legitimacy of the underlying order, if the FCC thinks that they can uphold the order under different rationale, the FCC often tells the reviewing court, give us another chance to do this before you look at it. That sometimes drives private litigants crazy because it delays the point at which courts will actually issue a decision, sometimes by 2 or 3 years. But it was an option available to the FCC here. I don't think they intended for this outcome to happen. I'm not attributing to them any bad faith in their decision not to follow that approach, even if it's the approach that I might have taken. But at the same time, there was a certain negligence, I think, in their failure to do that. And a negligence perhaps born of the sense that under the worst case scenario, they could always do the Title II thing if they wanted to. I'm not saying that they wanted to do that, but they weren't as concerned about the prospect of judicial loss as they might have been if they were worried that they would have no alternative legal avenues available to them. So I now want to talk about what's going to happen next. I guess I want to challenge an assumption that's been said a couple times today, that the Title II path is a path of less uncertainty than the Title I path. There's a lot of uncertainty in the Title II path, and I want to avoid conflating legal uncertainty with economic uncertainty. I'm attuned to that distinction, but there is a heavy confluence between the two of them. And I want to talk about 3 dimensions of uncertainty that are raised by this Title II approach. The first is the uncertainty created by the direct appeal itself of any FCC decision to reclassify. Often at events like this, and frankly in the public statements of policymakers, legal issues like those that will, if the FCC goes down this road, be aired in court, are elevated to 50,000 feet. And you hear a lot of statements like, well, Justice Scalia said it was okay, and he said the FCC was compelled to do the Title II thing. The others didn't explicitly say that the FCC was compelled to do the Title I thing, and therefore were likely to prevail at the end of the day. That's the level at which you hear a lot of the dialogue. The thing is that in actual appellate litigation, the issues are briefed and decided not at 50,000 feet, but at 5,000 feet, or 50 feet. And at issue in this case will be extremely factual questions about exactly how broadband internet access services are offered. And it is true that administrative agencies have a fair degree of discretion to change their minds on policy issues. And the Supreme Court adopted that position in the Fox case, as Chris points out. But there are 2 exceptions to the general deference that agencies get to any change of mind on important legal issues. And the Supreme Court spelled them both out in the Fox case. One is on factual determinations that the FCC has made in a prior order that it now proposes to disavow. The second is determinations that upset settled investment-backed reliance decisions. This case, if the FCC goes down this road, would present both of those exceptions to the Fox case. And it would do so in the name not necessarily of any changed circumstances, because the way in which broadband internet access services have been offered is not very different today from what it was 5 years ago. The difference would be solely the FCC would be acting to preserve its own jurisdiction. If I were a court, I would be skeptical about whether that is an appropriate basis for a change of mind. So that's the uncertainty associated with the direct appeal. We can get into the details, but frankly, they're boring, and I'm happy to talk about them with anyone afterwards if you want to. But there are legal risks attendant with direct appeal, and I would not assume that those legal risks are going to be resolved within the next couple of years. In fact, what often happens is that courts look at an agency's rationale and say, we don't think you did a very good job with your rationale. Conceivably, you have some alternative basis for doing this. We're going to bounce this back down to you again. And sometimes that game of ping pong between agencies and courts can last up to a decade. And we saw this, for example, in the case of the Iowa Utilities Board litigation that Chris has talked about and that George mentioned in his speech. The FCC, in that case, adopted a similarly in 1996 adopted a similarly backward-looking, didn't seem to be at the time to be backward-looking, but in retrospect looks like a backward-looking, essentially resale-based model of competition in the telecommunications industry under the name UniP. And that's yeah, so the UniP under Telric, those are like old terms, they're flashed in the past. But that whole set of issues got bounced back and forth between the court and the FCC for 8 years. It ultimately got invalidated in 2004, 8 years after it was initially adopted. It is folly to think that the legal issues presented even on the direct appeal here can be resolved within a short time period, given experiences like that. Okay, that's just the direct appeal. The second dimension of uncertainty involves implementation. There are a host of questions involved in what the FCC is proposing to do here precisely because it is so novel. They are proposing to cram internet players into regulatory silos that were designed for the 20th century monopoly telephone market. And no one, even if they get away with that on a legal basis, no one knows exactly what that would mean in practice. So there are a variety of questions. Who is affected by this? There are a lot of arguments, pretty strong ones actually. The Title II reclassification is not a scalpel, but a sledgehammer, and it would affect not just broadband internet access providers, but just through the sheer self-executing logic of the FCC's statutory reclassification could affect other important players in the broadband ecosystem as well. We won't know the answer to that for several years. We don't know in particular what regulatory obligations would be applicable, even if you focus narrowly on broadband providers. The FCC claims that it will forbear from all provisions except 201, 208, and a handful of others, including 254. We don't know whether they will succeed in doing that. There will certainly be an interesting tension between the arguments that they make in favor of forbearance and the arguments they make in favor of the statutory reclassification in the first place. But on top of that, there are a lot of self-executing regulatory obligations that arise simply under 201 and 202. In fact, if you're a staffer at the Commission, one of the things that you'd like to do, just to cover your bases whenever you write a new regulation, is in the little box where you cite your statutory authority. You always throw in 201 and 202. Why not? I mean, those are the founts of regulatory obligations under Title II. There are a lot of provisions that may or may not apply, even if they forbear from everything except 201 and 202, because a lot of self-executing regulatory obligations are contained in 201 and 202. And we won't know even what 201 and 202 themselves on their face mean. We don't know, for example, what a non-discrimination obligation means in this context. Does it, in some self-executing way, produce the net neutrality regime that the FCC was producing in the fall? I would argue not, actually, in important ways. Another complex set of issues, but other people argue that it would. That wouldn't be resolved for several years as well. And then there are all the questions about whether the FCC can get away with unforbearance. We'll see, actually, just how seriously to take the FCC and its claim that unforbearance is very difficult because there are initiatives to unforbear from a number of proceedings, as George pointed out. Finally, just one more minute on this. The third dimension of uncertainty, and this is really important, I think sometimes overlooked. Under the Title I regime, there were no rules that could be imposed against any provider unless the FCC spelled out what they were with some degree of specificity beforehand. No self-executing obligations. There was just a case-by-case exercise of FCC regulatory authority. The Title II world is very, very different from that. And I want to make an analogy to the National Labor Relations Board. The NLRB does not issue very many rules, if any, on substantive issues involving what constitutes an unfair labor practice. Instead, it does it through case-by-case adjudication, and employers are just on notice that whatever they do, they cannot commit an unfair labor practice. And then the labor board gets around to deciding what that means, and if what the employer has done violates the labor board's retrospective view of what constitutes an unfair labor practice, the employer will be liable as a matter of law for that. These are underlying self-executing legal prohibitions. What the FCC is proposing to do is to adopt a rule like that for broadband internet access providers. where you can be liable either to this commission or to some future commission for what you do today. If some future commission decides that whatever you did constitutes an unjust or unreasonable practice or an unreasonably discriminatory practice, that actually should create a lot of legal uncertainty. It could, for example, deter broadband providers from entering into anti-piracy type arrangements with content providers. It could deter them from entering into pro-consumer partnerships of various applications and content providers. It just casts a pall over the industry. It's self-executing. It creates uncertainty because you don't know what will be held liable for doing 3 years down the road. Thank you.
Great, thanks. Well, building on that, let's speak about actually other related items. Wireless. You know, one of the big arguments, and George talked about this a little bit, is that this third way is just like wireless. And it's true that CRS voice was the tariff back in the early 90s, and wireless broadband, I guess 2007. But is this really the same? And as you know, we pointed out in our paper, for an administration that says, I want wireless to be #1 in the world, we want to do this, let's just look what's happened. We've got the Harbinger order, which they snuck out a spectrum cap out on de facto spectrum cap on delegated authority, which is an issue that's pending before the commission. We've got the bill shock proceeding, which is price regulation. We get handset exclusivity, ETFs, all this kind of stuff. Is this like the wireless model, or is it not? Kathy?
So before I get to wireless, I think after that exhaustive and exhausting presentation about what happens when you go down the Title II rabbit hole, I think I want to make the case again that all of that is going backwards in a very different, changed world, and that the answer really lies in a congressional inquiry, which is underway, and a congressional consensus on what it is we're trying to do here. So let me start with the notion that if any regulation is required at all, and we would say it's hard to even understand what harm is being addressed here because there hasn't been any proof of harm, but for 2 cases that quickly got decided. But if that were the case, then the case-by-case approach that was complaint-driven based on some actual showing, factual showing, that competition for a consumer somehow was hurt, may well be an appropriate intervention by the government. So there's a consumer protection and a competition protection kind of notion in the law that I think, and my esteemed colleagues will correct me if I'm wrong, already exists in the law, in my view, under FTC jurisdiction. Now, to the extent that there needs to be clarification as to what happens with respect to the internet in terms of harm to consumers or competition in a blocking kind of situation, that can clearly be decided by the Congress and put into law. So I start there. To then go to the wireless statute as a model for agency intervention, as opposed to thinking about what the Congress thinks about this, in my view, is also it's confusing to me. The wireless statute, now again I'll let you do the legal analysis, is interesting in the respect that it was an attempt by Congress at the time to actually let a new technology take off, with a little bit of worry that because this was voice, we better watch out because we're worried about voice, and I think that comes through in the statute. It's about voice. That statute is not about high-speed wireless internet. Now, as a company, we sit and listen to this, as a company that has $17 billion on the table, year in and year out, and indeed has relied on a regulatory regime where we are right now building 100 megabit fiber optic cable to the home and starting to roll out a 4G LTE wireless network that is fundamentally going to change this entire field again. it is in the very least discouraging to think that what America says they want, which is new and faster platforms for new and more innovation, for the investment of capital all over this ecosystem that is going to create jobs and the whole new world, to think that that is tied up in what we just heard for the last hour is a frightening thing. It gives you a rash. Believe me, I'm with the guys who are building these networks in our company, and they just look at you like you're insane. What are you really talking about? I had this one fellow who keeps saying to me, I don't even want to go to Washington. You know, these are the folks who are trying to, right now, engineer a wireless network that is going to take us from a 3G world to a 4G world, and we're trying to do this in 3 years. 3 years. Now, right behind us are 4 and 5 other competitors that are eating at our heels. And to think this is where we're sitting and this is the conversation we are having. So I don't know about the definition of uncertainty. I don't know about the definition of credibility. What I do know is that this is for real. And if it's for real, and if the goal of the administration is, and we completely are in accord with this, to ensure that the United States has the leading edge, high-speed, best platform in the world for the future of this country and the world, I do believe, then we've got to get rid of this. Now, that is why Verizon has been at the forefront in seeking a way to get to yes. And I just want to take one more minute on this. We have agreed from the beginning of this debate that the end-to-end principle of the internet is one that is of high value to the country and to the world. And that we took the pledge, I think, Link probably wrote it 6 years ago. We will not block, we will not, impede connections, devices, apps on the internet, and we have not done it, and we've lived up to our word. We have had over time an evolving notion of what this idea of net neutrality even is, and it has then progressed to a notion of transparency. I don't think anyone in the industry thinks that transparency is a bad idea. I think we think that consumers ought to know what they're buying, they ought to pay for what they think they bought, they ought to know what the apps are, what kind of bandwidth they're getting, what kind of bandwidth is used by an application. They ought to have that information. Now, how do you do that, and whether you should have a priori rules set by an agency I still love very much, but by rules by folks who are sitting there saying, let's have these 959 rules around what you're going to put on a page. We went through this in privacy. Everybody think about your privacy statements and tell me whether you ever read them. We're going to do this, and does that really help the consumer? This notion that we, the industry, the collective ecosystem, ought to be transparent and ought to be telling our customers what they need to know is something we live with every day. If there has ever been a consumer group that keeps the fire to your feet, it is the internet community. They don't let much go by for very long, and they require that we do this. So, that we have this kind of principle in law is something we agree with. We do not agree and cannot really deal with a rule-making kind of regime that would bring us back into this kind of conversation day in and day out.
Okay, can I make a quick point on this? I forgot to make my disclosure and disclaimer. The disclosure is that, and it should come as no surprise to those people in the room, I'm a lawyer, I am a practicing lawyer, and I have clients who are broadband providers. And so bear that in mind when you listen to me talk, but also I'm not speaking for them. But this actually raises an important point from what Kathy just said. There's an inverse relationship between my welfare and the welfare of my clients in this set of meetings, because what the FCC is proposing to do here is to create a lawyer's paradise where all sorts of issues, just like endless layers of issues about what Title II regulation means in this brave new world, that will send my kids to college and their kids to college. At the same time, I hope for the good of the country that I'm impoverished and that this, or at least that this is not the way that I develop a successful practice, because this kind of uncertainty isn't good for American consumers. And frankly, these sorts of issues are not satisfying to me as a lawyer, because I would much rather be spending my time talking about actual policy issues that affect the way these services are actually offered than parsing words in a statute that was based on legal classifications developed in the 1970s and 1980s. That to me is intellectually really unsatisfying.
Let me repeat the disclaimers, which of course always follow.
By the way, for both of you two, you could be like me and be a lawyer, but have a crisis of conscience and then go work for a think tank. Not the word.
Well, I'm not going to, because it is a lawyer's paradise, no matter what.
We like to refer to it as a fertile ground for research.
John, let me say that I agree with everything John said about 3 dimensions of uncertainty. Well, maybe not everything, but almost everything. A lot of uncertainty down the Title II route. I think there is less uncertainty down the Title II route than to trying to use the Title I route. If you go to the Title I route, we're going to have even more cases where the question is going to be whether this is ancillary to some statute that was statutory provision that was written not thinking about the internet, but that's the way, and it'll be case by case, and you'll have uncertainty in every one of those cases as you go
Chris,
along.
what about a new statute?
But you know, a new statute would truly be a lawyer's paradise.
Well, it depends what the statute says. I mean, there are consensus versions of the statute that say FCC. You know that Internet Policy Statement you adopted in 2005. There seems to be a lot of consensus behind within the industry. You have authority to enforce that. End of story. Oh, and you can also fund broadband. There is a lot of consensus behind a statute like that. The lack of consensus in terms of the legislative work turns on, what additional obligations some people might want to put in the legislation.
I mean, you guys raised a good point. I mean, we did a paper. What struck me is that the FCC in their open internet, NPRM, actually tried to use 251 as a pricing statute. It was just this absolutely tortured interpretation, which ended up actually being totally inconsistent with 201, 202. And they just didn't, we went back and actually pulled the original 251 order, and it was inconsistent with that. So you're absolutely right. So then it seems to me, I'll leave this as a final policy question. We'll get to questions from the audience. Putting aside the arguments that we need to reclassify because it's the only way we implement the national broadband plan. I personally don't believe that. I don't get it. But it's this net neutrality issue. And it seems to me that the 2 net neutrality, open internet, whatever you want to call it, issues are on one hand, transparency, on the other hand, some sort of blocking. And what's interesting, if you look at the FCC's own Truth in Billing NPRM, which was released maybe about 3 or 4 months before the Comcast case, they did an amazing job of a Title I argument, citing cases where they were already upheld for this. So it seems to be, why are we going back to this? And then if we're going to focus on, this is why I don't believe, my own reading of the statute is, the Communication Act focuses on the relationship between the carrier and the customer. So it never tells you how to make the sausage, but it will tell you how to put the sausage on the table.
I mean, when you think about the existing law in the absence of congressional intervention, it's not just Title I, by the way. If you want to fund universal service, there are ways to do that, even in addition to 254. Right. For example, Section 706B would also provide a basis for funding universal service. With respect to transparency, the Comcast court itself said that the FCC has at least some authority under Section 257 to require disclosures, at least to the Commission and arguably also to consumers.
And so, how dare me to act like a lawyer, but I am. But I keep wanting to say to my cable friends, and were you ever a common carrier? I think I know that law, and I don't think they ever were a common carrier. So I'm still having a really hard time on how this all works, because there's no such thing anymore as a cable provider, a telecom, where there's internet access providers. And they come in all kinds of forms and flavors, but they're not common carriers.
The other thing is that it's because they're not common carriers that the FTC has jurisdiction over them. And there's a really interesting interagency turf battle going on here that doesn't make the press very much. The FTC quite arguably has jurisdiction over broadband internet access providers today on privacy issues, on competition-related issues, because the FCC has decided they are not common carriers. The problem, of course, is that the FTC is limited in its jurisdiction by something called the common carrier exemption, which tells the FCC that it may not exercise authority over any entity deemed a common carrier. If the FCC switches and puts broadband providers within the scope of Title II common carriage regulation, it strips the FTC of that authority. In some respects, the federal government's authority over broadband providers doesn't change all that much through this action. You just see a shift of authority from one federal agency to another.
Well, I'm sorry.
Then I just want, so one last point on wireless high-speed broadband access. That's not, that was not even, we don't even know what that is in the statute, right? It wasn't invented, it wasn't there. But the FCC does have a policy. And that policy was made clear in the 700 megahertz auction. And that is that it would like the broadband internet access network to be open. And in fact, put conditions on the licenses that were awarded to ensure that if there was at least one nationwide carrier, that would be us, who decided to go that route, buy that spectrum, and be open, that the rest of the market would likely follow. That is, that there would be real market forces that would happen that would drive toward that result. That's already happening. It's already happening.
Why don't we open the floor to one or two quick questions, because Commissioner McDowell's here. So, Scott.
The title of
Wait
this...
for the mic.
Whoops. Oh, thank you. Just a simple question based on the whole purpose of this, of George's article, which is credibility. And what is the downside? What's the problem when the FCC acts in such a fundamental big way without credibility? What are the ramifications?
Well, there's been a bunch of articles in the last week that have been fascinating. I think Fareed Zakari's article was really interesting. This morning in the Wall Street Journal, I think there were 3 or 4 of them. I was most interested in David Wessel's article about what happens in sort of like this misunderstanding that happens between what government cares about and what their goal is and what business is trying to accomplish at the same time in terms of investment. And when you get this I'll call it a misunderstanding of sort of goals. Everyone says we're going in the same direction, but you're giving each other cross signals. What happens is cross signals. And what happens is folks go, maybe, what direction am I going in and should I be? And that, I think, with George's point on investment, you know, you're not going to see, I don't think, major carriers say, well, we're not investing in it. That's not what happens. But decisions are made about where to put your capital because that capital has to have a return. And when you see your market cap sliced in half, you got folks who say, what are you guys doing? So I think that we're at a very, this is real world right now, in a very difficult economic environment. There are very difficult economic decisions to be made, and clarity about direction seems to me extremely important.
Well, that was, oh, sorry, Commissioner.
Well, I was just going to respond to, you know, again, there is uncertainty. There's considerable uncertainty. There will be considerable uncertainty for a long time. I actually think there's probably less uncertainty under a Title II approach than a Title I approach. On the other hand, there is a greater probability that more FCC regulations will be upheld under a Title II approach than a Title I approach. So I don't think it's so much about uncertainty as about how much regulation might get struck down and how much regulation will get upheld.
Yeah, what type of uncertainty? Any other questions from the floor? Because I have one, nobody else does. Dennis Will.
Well, this is just a topic that a couple of people have brought up, and so all of the discussion about relative degrees of uncertainty has been about 2 different courses that the FCC might take. but as several people have mentioned, subject to what the FCC does in terms of the path that it chooses, the Federal Trade Commission might actually have authority to deal with most of the issues that are the subject of the discussion. What does that do to the, if the FCC were to defer to the Federal Trade Commission, what would that do to the level of uncertainty in the marketplace going forward?
To me, this is why we need clarity. This is why it is time for Congress to act and to say this is a changed world with regulatory oversight, which was constructed for a different time and a different day, with jurisdiction awarded to various agencies under very different circumstances, and we need to look at the internet policy. And and we applaud the 4 chairmen who have said, please come up here, it's time for us to look again.
Okay. George, did you have one question, or just real quick, we'll get it?
Yeah, well, we got the commissioner, but John brought up the point I thought was interesting, somewhat related to this discussion. If the FCC imposes some obligations under Title II and tries to implement the network neutrality issue, which is often cast as an anti-competitive behavior, does Trinco become applicable to a response if somebody wanted to sue, say, an antitrust court? Is the court going to say, oh, well, no, the FCC has taken authority over this network neutrality issue, so go deal with them, we're not going to pay any attention to that as an antitrust question?
Yes, I mean, as the FCC's regulatory authority waxes, the FTC's regulatory authority wanes, and so does private antitrust enforcement under Trinco. Under Trinco, with respect to private antitrust enforcement and DOJ enforcement, for that matter, and the FTC under the common carrier exemption.
That's got all the questions. Any other questions?
All right.
I think I want to say something about Kathy's point was very good as well. We focus a lot of times on investment and capital expenditures as a measure of investment. You can create rules that increase capital expenditures but reduce social welfare. It depends on the price elasticity demand for capital, for example. I could raise the price of capital, tax capital, for example, and actually get an increase in expenditures on the financial books of companies. It depends on the elasticity of demand for capital. So it's not always the case. Or Verizon could say, I'm going to stop investing in the U.S. and start investing in Germany. And you may actually see no change in capital expenditures, but clearly a change in the regulatory response leading to a reduction in the well-being of the United States.
Well, again, I want to thank all of my friends and colleagues for being on the panel. It was truly excellent. Thank you all for coming.